Good morning, everyone. This recording is intended for our criminology students for their criminology licensure examinations. And in order for them not to be exhausted of the readings of the different caudals of the different subjects, this recording is intended for you um, to hear the caudal provisions without reading it. All you have to do is to have your headset no, while you are traveling para naman yung mga mata natin ay makapagpahinga. So you can um, utilize this audio recording for that purpose. This is also intended for our law student and those who are taking the bar examinations very soon. And we have exercises as we go along with reading the codal provisions of Criminal Law 1, Book 1. You can answer them and assess yourself if pwede na ba tayong mag-exam. Okay? Criminal Law 1, Articles 1 to 10. The Revised Penal Code Act Number 3815 passed on December 8, 1930, but our Article 1 time when Act takes effect was on first day of January 1932. These are the general provisions regarding the date of enforcement and application of the provisions of this code regarding the offenses, the persons, and liabilities and penalties. Book 1 of Criminal Law. Now, what is the difference between criminal law and a crime? Criminal law is that branch or division of law which defines crimes, treats of their nature, and provides for their punishment, while crime is an act committed or omitted in violation of public law forbidding or commanding it. And for jurisprudence, from the Latin term jurisprudentia, which means the study, knowledge, or science of law. It is the course of court decisions as distinguished from legislation and doctrine. Date of effectiveness and application of the provisions of this code. Article 1. Time when Act takes effect. This code shall take effect on the first day of January 1932. Article 2. Application of its provisions. Except as provided in the treaties and laws of preferential application, the provisions of this code shall be enforced not only within the Philippine archipelago, including its atmosphere, its interior waters, and maritime zone, but also outside of its jurisdiction against those who, first, should commit an offense while on a Philippine ship or airship, second, should forge or counterfeit any coin or currency note of the Philippine Islands, or obligations and securities issued by the government of the Philippine Islands, third, should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number. Fourth, while being public officers or employees, should commit an offense in the exercise of their functions. Or fifth, should commit any of the crimes against national security and the law of nations defined in Title 1 of Book 2 of this code. The Bill of Rights of the 1987 Constitution imposes the following limitations. First, no ex post facto law or bill of attainder shall be enacted, that is under Article 3, Section 22. Second, no person shall be held to answer for a criminal offense without due process of law, under Article 3, Section 14, Paragraph 1. The first limitation prohibits the passage of retroactive laws which are prejudicial to the accused. An ex post facto law is one which, number one, makes criminal an act done before the passage of the law and which was innocent when done and punishes such an act. 2. Aggravates a crime or makes it greater than it was when committed. 3. Changes the punishment and inflicts a greater punishment than the law annexed to the crime when committed. 4th, alters the legal rules of evidence and authorizes conviction upon less or different testimony than the law required at the time of the commission of the offense. 5. Assumes to regulate civil rights and remedies only, in effect imposes penalty or deprivation of a right for something which, when done, was lawful. And 6. Deprives a person accused of a crime some lawful protection to which he has become entitled, such as the protection of a former conviction or acquittal, or a proclamation of amnesty. Bill of Attainder is a legislative act which inflicts punishment without trial. Its essence is the substitution of a legislative act for a judicial determination of guilt. That is fully explained in People v. Ferrer, 48 SCRA 382 and 395. Example, Congress passes a law which authorizes the arrests and imprisonment of communists without the benefit of a judicial trial. That is a Bill of Attainder. Article 3. Definitions. Acts and omissions punishable by law are felonies or delitos. Felonies are committed not only by means of deceit or dolo, but also by means of fault or culpa. There is deceit when the act is performed with deliberate intent, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Article 4. Criminal liability. Criminal liability shall be incurred, first, by any person committing a felony or delito, although the wrongful act can be different from that which he intended. Second, by any person performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment, or on account of the employment of inadequate or ineffectual means. There is no crime and there is no law punishing it. That is the very famous doctrine. Article 5. Duty of the court in connection with acts which should be repressed but which are not covered by law, and in cases of excessive penalties. Whenever a court has knowledge of any act which it may be deemed proper to repress and which is not punishable by law, it shall render the proper decision and shall report to the Chief Executive, through the Department of Justice, the reason which induced the court to believe that the said act should be made the subject of legislation. In the same way, the court shall submit to the Chief Executive, through the Department of Justice, such statement as may be deemed proper, without suspending the execution of the sentence, when a strict enforcement of the provisions of this code would result in the imposition of a clearly excessive penalty, taking into consideration the degree of malice and the injury caused by the offense.